Is your business protected against the threat of malicious litigation and frivolous lawsuits? Are you sinking company profits into marketing campaigns that do nothing to contribute to the growth of your business? Bottled Business Sense provides practical business perspectives that uniquely emphasize both legal and media marketing strategies to protect and ensure the longevity of your business. And whether you're trying to provide a startup business with some level of stability or an established business with foolproof asset and estate protection, or simply attempting to get a better return for your business marketing dollars, Bill Bernard and Rick Moscoso will expose potential pitfalls to ensure the security and growth of your business, free from unwanted expense and the threat of litigation. You'll learn how to implement marketing and protection tools equal to those used by today's most successful corporations. Let's join Bill and Rick for today's Bottled Business Sense show.
Good morning, everyone. Today is Tuesday morning here on the Bottled Business Sense Show. It's 10 a.m. as usual, and we're here for another episode of the Bottled Business Sense Show. I am Rick Moscoso, one of your co-hosts, and I want to welcome all of our returning viewers and listeners out there, as well as our new viewers and listeners. Welcome to the show. We are a weekly simulcast, and we speak to different business topics, marketing topics, legal topics to help your business run efficiently and safely, as well as hopefully, protected in the right way so we can really focus on the thing that we formed the business for in the first place, and that's making money, being profitable. So with that being said, we'll just roll right into it. Want to welcome my co-host on the other side, Mr. Bill Bernard. How you doing today, Bill?
Doing great, Rick. As always, thank you very much. Last time we spoke about a viewer, John, who called in and wanted us to speak about the frequently asked questions about a California LLC. Well, believe it or not, Laura contacted me, and she wants to talk about the reasons for estate planning. And I said, I'm going to take this one step further, Laura. I'm going to do a show on the reasons for estate planning under any circumstances, because estate planning is more than just one document. As I've said many, many times, when I do my estate plan for people, I do an estate plan or a trust package, which includes 10 to 12 different documents. Well, you can do different types of estate planning because those documents comprised in my package are all part and parcel of an estate plan. So you may want to amend an estate plan, you may want to supplement it, you may want to create a new one. And many times people say, well, do I have to have a certain amount of money in order to create an estate plan? Well, I'm going to give you reasons why I think everyone should have an estate plan today. Because regardless of your net worth, estate planning is really to ensure that your wishes are executed and that your families are adequately provided for. That's really the basis for estate planning. In some instances, it can overlap into asset protection when you talk about irrevocable trusts. But let's say you're talking about a revocable trust, which most people get. Let's stick strictly with estate planning issues and not asset protection. Without an estate plan, the government and the courts decide who will inherit your assets, right? Who will become the guardian of your minor children, if you have any? Who will make your healthcare decisions? Who will make your financial decisions if you become incapacitated? Without regard to your wishes. I mean, need I say more? Need I say more? Why would you not want some portion of an estate plan if the government and the courts are going to make all of those decisions in your stead?
Right. I'd be a little concerned if the government was handling my personal affairs. I don't know about you.
Well, I certainly would be. The statutes are designed, Rick. The statutes are designed. They're designed to accomplish what the government thinks your estate plan ought to be. Now, I don't want anybody to get the impression out there I'm anti-government, but I'm anti-government when it comes to interposing their desires or its desires on my family and what I would like to see accomplished when I'm gone. So with all of that in mind, that should be ample reason in and of itself to have an estate plan. Forget about everything else. But let's go through some specifics. Well, you certainly want to. Here's a bullet point that we want to talk about. Designate beneficiaries of your estate. if you don't have either a will or a trust, your property is going to be dispersed intestate, meaning that the government becomes your individual estate planner and decides who's going to get what when. Now, statutes are designed to help get family members in a line of succession your assets. However, you may not have agreement with Aunt Molly getting the house, right? Or Aunt Jane or Uncle Tom getting a certain account. You're going to want to decide who you want to be your beneficiaries. It's very simple math. Very simple. Here's another big one. Second bullet point, appointing guardians and trustees for minor children. If you have minor children, Rick, without a will or a trust, the court is going to appoint a guardian for the individual minor child. What does that mean? Well, it means having a court-appointed guardian can also result in complications in estate management. Money that you may want to pay for your children's education, clothing, and living costs are going to all require prior approval by the court. They're going to require prior approval by the court. And furthermore, the law is going to jump in and do annual accountings of income and expenses to the court. Investment funds, if a guardian wants to invest funds and that guardian is appointed by the court, he or she may very well be limited by the choices that only the court approves. Whereas you may want to take a bigger risk than what a court-appointed guardian may want to take. Right?
Yeah.
So the court may prevent your children's funds from growing at an acceptable rate by interposing its own view on your estate because you don't have an estate plan. That was the second big point. And these are, by the way, not only things that we had our viewer ask about, but these are a lot of questions that I frequently get asked about estate planning issues.
Well, just those two questions or those 2 points in and by themselves is enough to wonder, is enough to ask, why don't people pursue a personal estate plan?
Well, it's the old story, Rick. It's either, why do I don't want to pay for an oil change and a tune-up, but I'd rather spend a lot more money later on getting a transmission rebuilt. People either don't want to spend the money, or I hate to say it, but another big reason is people are just simply selfish. They really don't care. They take the attitude, hey, when I'm gone, I really don't give a damn what's going to happen. It may be a little hard to hear, but there are people out there that take that point of view. The next bullet point, here's a great one, appointing a healthcare agent. If you become incapacitated, don't you want to appoint somebody who's going to be able to take care of you, who you trust, my God, with your life? Right? That ties right into number 4, the next bullet point, appointing agents and trustees to manage your assets in the event of incapacity. Clients with businesses, which are the majority of our listeners and viewers, right, may want to name different people for purposes of running their company and managing their personal affairs. Do you want the court to do that?
Absolutely not.
Do you want the court to step in and say, okay, here's who gets your business? Or if you're incapacitated, hey, the court is going to appoint someone to take care of your affairs while you're incapacitated. Not to mention, you may have somebody appeal to the court for that job that you may not want to have that job.
So let me ask you, and you can paint a picture here for our listeners out there. So let's say I own a company, and my wife is not part of the company, and I pass, and I'm not protected, as you are suggesting.
Well, are we talking about you passing, or are we talking about you becoming incapacitated?
Okay, so I'm incapacitated. First, let's talk about that. So I'm incapacitated. What and who would be appointed to control?
It's been that way for a number of years, hasn't it, Rick? I couldn't help it. I'm sorry. But no. Okay, so you're incapacitated. And, typically speaking, if you have some sort of an agreement in place where your wife is going to be able to run the business, nobody's going to terribly interfere. But let's say you have a business partner, and that business partner and your wife are fighting, And now that business partner probably has the right to run your business in your stead if you have your agreement set up right. But what if your wife goes to court? What if your wife wants to contest it, or someone else wants to contest it? The point is, if you have a power of attorney, a durable power of attorney for assets, it says specifically who's going to run your portion of the business. So if your business partner does take over, somebody's going to be able to work with your business partner and say, hey, wait a minute, I'm sticking up for Rick's best interest. Here's what we have to do for Rick. And here's the agreement we have to abide by. Our operating agreement, or our bylaws, whatever kind of an entity you might have. I mean, it's critically important. So we've just named 4 issues that alone, any one of them alone, would make you want to have an estate plan. The next one, protecting beneficiaries from him or herself. Let's say a trust is an ideal tool for this, because a trust can be used to distribute funds over time to protect an asset, to protect your assets from beneficiaries whose own misjudgment may cause them to spend the money wildly, right? So you've got an estate plan that says when I die, my son doesn't get my money. He gets it in proportion to different ages that he turns, or he gets it in one lump sum when he turns age 30, and hopefully by then he's mature enough to do what's right, right?
Yeah.
You also can set up a special needs situation. What if you have a child who has who's autistic and they need special needs for their medical care over time? Do you want the court making those decisions, or do you want to be able to make those decisions?
Right.
The next bullet point, I guess this is in the vicinity of number 6. You protect beneficiaries from creditors and divorcing spouses. Do you want a ex-husband or ex-wife coming in and claiming some of your affairs if it's not in a trust or an appropriate estate plan that provides protection from creditors and potential divorces that may come down the line before you pass? Then bingo, you're going to have a problem, because in that divorce settlement, your ex-wife or your ex-husband is going to get something that maybe they wouldn't ordinarily be entitled to get.
Yeah, you're going to be in for a very ugly situation, it sounds like.
It certainly is an ugly situation, and that's why I don't do family law. But if that's not enough for you, let's go to number 7, the next bullet point, appointing an executor. Appoint an executor. Most people prefer to select someone they know and trust to oversee their estate rather than having a court appoint an executor of its choice. Well, we've already kind of discussed this. I pointed out again as a separate bullet point because I want to reemphasize the court intervention here. What if you have a large estate? Number 8 comes to mind. You want to minimize estate, gift, and income taxes, right? If you have your trust set up properly, you can avoid, by using tax-deferred tools, you can avoid certain estate and gift taxes that you wouldn't ordinarily avoid if you didn't have a proper estate plan. So taxes becomes very, very important. These estate plans, folks, are intricate, and they need to be set up by someone who knows what they're doing. So let me impress upon you, if you're a DIY person, be careful, because most DIY people end up coming back to an attorney later on when they find out the mistakes they've made. The second to the last bullet point would be supporting a charity. You may want to leave certain funds or certain assets to a charity. Okay, you're not going to get that through a court intervention if you have no estate plan. And finally, number 10, the last one, and probably a biggie. Well, not probably, it is a biggie. Got a guess at it, Rick?
Not a clue. Go ahead.
Avoiding probate. Right? Without an estate plan, a trust specifically, you go to probate court. That means costs, court costs. That means attorney's fees. What if you have property in different states? Now you've got to open up separate probates in each state where the property is located, as opposed to having a trust in California or in one state that you reside in. All of those properties from different states come under the rubric of that trust that you have. So in this case, I'm specifically talking about avoiding probate by way of a living trust, because even if you have a will, you avoid a lot of the other things by appointing people that you want to get your estate without the court's decisions in that regard, but you still have to open probate. Remember, the only distinction between intestate succession, where you have no will and no trust, and a will is that the will says who gets what over intestate succession, which is ruled by statute in the courts. The only way to avoid probate altogether is to have a living trust. So
would there be any instance then? I know you're a huge proponent of, and you always talk about the trust package. Are there instances where, unless you're asked otherwise by a client, that you would just do a will?
In one circumstance where, two circumstances where somebody just, no matter how hard you try to convince them, just says, all I want is a will, I don't want a trust. There's really no discussion there. Or where somebody has a lot of trust documentation already and needs a pour-over will, because a pour-over will in short form is basically something is left out of the trust. You want to show the court by filing an affidavit that the property was mistakenly left out and should pour over into the trust. You want to have that pour over will. Under those circumstances, I would. But remember, this trust package now that I speak of is a living trust. It's a power of attorney for assets, a power of attorney for healthcare. It's a healthcare directive. It's a guardianship document. It covers everything that you need to go run the gamut of these bullet points that I've just pointed out.
Yeah.
So Laura, I hope that helps her, our viewer that requested this, because these are, folks, reasons why you want an estate plan under any circumstances, not just when your estate is a certain value. And why is that so? Because estate planning encompasses more than just one type of specific document.
Yeah, it would make sense to me then that for our listeners out there to fully protect yourself and take the advice or take the recommendation of Bill and invest in a trust package like he promotes. So you're in full control of what decisions you would like to be made of all your assets and your health and just all the topics that we talked about today. So I know, Bill, that we've been working on something in the background that's going to be released pretty soon, and that is one of your websites that you're going to be promoting what we're talking about here. Tell us a little bit about what you have coming down the pipe.
Yeah, Protect Your Estate 365 is part of, it's an offshoot of WFBLegalConsulting.com. At WFB, you'll learn about everything I do as a business lawyer, but there are separate landing pages for employment law, for estate planning, and for asset protection. And this landing page for estate planning is now going to be turned into a full-blown website, still going to be called protectyourestate365.com. I call it PIE, P-Y-E 365. But it's going to be geared with a lot more intricacy. It's going to have videos. It's going to have questions and answers to a lot of concerns people have. It's going to have pricing on it, depending on what type of estate you want to get done. It's going to really appeal to the consumer who wants not only a simple basic trust, because I find a lot of those people are left out in the cold and are overcharged, but it's also going to have information on there about more intricate and more voluminous estates that have larger values, I should say. And it's going to allow somebody to interact by signing up, by getting a worksheet, filling it out, and providing it to me, and we're able to get the ball rolling very quickly. And because remember what I said long ago, Rick, that when I did a survey a while back to clients, one of the things they were really concerned about, besides price, was the quick turnaround. How quickly are you able to turn around projects or things that I need to have done as a client? And this website certainly promotes that, although I pride myself on getting that done quickly anyway. This website makes it even quicker for folks. So I'm hoping everybody will take advantage of that.
Awesome. And then in future episodes, we'll be announcing the release of that website as well as some other press that we will release via wfblegalconsulting.com. So be on the lookout for that. If you have any other questions or want more specific details about the topic that we talked about today, then please reach out to Bill. His information here is below. You can also reach him directly at what phone numbers, Bill?
949 area code 698-6222 and 413-6535. And of course, at bill@wfblegalconsulting.com or the current landing page for protectyourestate365.com.
Excellent. Well, thanks again, Bill, for all this information. It can be very eye-opening when you hear this episode and realize that some of your things, when you pass on or you get sick and you're at the point where you can't take care of yourself, may not be under the people that you want it to be. So please rewind this episode, take a look at it again, and then reach out to Bill if you have any more questions, because there's a lot of valuable information here in this show. So thanks again to our viewers and listeners for joining us. I'm Rick Moscoso, one of your co-hosts here on the Bottle Business Sense Show. And Bill, any final thoughts before we check out?
Just to say, I hope to see you next week, and I want you to take care and have a very prosperous business week, everybody.